First District Court of Appeal is now open. All that business for this court are on hearing and attention and shall be heard. God save the United States, the great state of Florida, and the honorable court.
Please be seated. Call first the case of Gary Ferguson against Universal Property and Casualty.
Good afternoon, Your Honors. My name is Ty Tyler. I have the privilege of representing Gary Ferguson in connection with this matter. I would ask to reserve 5 minutes for rebuttal. This appeal arises from an adverse verdict against Mr. Ferguson based in part on a jury verdict on one issue and on a directed verdict on another. The first issue that I'd like to discuss is the failure of the trial court to give a jury instruction on the legal effect of an agent's knowledge of facts and whether the imputation of that knowledge to the insurer. In this case, which arises from an insurance application, the issue is there was an application taken which Mr. Ferguson signed. He denied being asked certain questions which appeared on the application as being answered. There was substantial evidence because the application was taken by phone, indicating that there was a good chance that he might not have actually there might not have been time to ask those questions.
Well, there was a phone conversation, and then the application was faxed to him. Is that right?
That's correct, Your Honor. It was faxed to him later in the day, and after it was faxed, the agent contacted him by telephone again and asked him to sign it immediately and return it before 5 o'clock. Phone records indicated that that call was placed around 4:50. And the application finally arrived at 4:56 based on the records. He did exactly as instructed. He signed it and immediately faxed it back. The question on the application at issue was whether in the 10 years prior to the application he had been arrested for DUI. He had been.
Let me ask a question. If I understood correctly, the instruction that you ultimately wanted given that wasn't was something to the effect of facts within the knowledge of the agent while acting in the proper scope of his authority as knowledge to the insurer.
That's correct, Your Honor.
And the fact that was in the agent's knowledge that you want imputed to the insured was that the agent didn't read the question to him?
That the only
ask the question?
Yes, sir. The only way that question could have been answered was if the agent answered it herself. And if she answered it herself, she had no basis to know whether it was correct or incorrect. There's no allegation that she actually knew he had been arrested for DUI. There's no evidence of that.
But what knowledge would be imputed? I mean, the cases that I read, Gaskins being an example, there was information, facts that were known by the insurance agent that was imputed to the insurance company, even though the insured had not read the application to discover the problem. There isn't, as I see it, a fact here.
There is a fact, Your Honor, and that fact is that the answer did not derive from Gary Ferguson. The answer came from the agent. That is a fact that's imputed to the insurance carrier, that it's the agent's answer and not his. And particularly in this case, there's a reliance component in a misrepresentation case, Your Honor. Here, the allegation was not objective materiality under the statute. Rather, in good faith, had we known the true facts, we would not have issued. If their agent is in possession of the true facts that she did not answer this question, that the insured didn't answer the question, that is imputed to the insurance carrier. And I suggest that the court goes a long way toward diminishing the good faith argument under subsection B of 627.409.
But isn't the question, or isn't the instruction you really wanted something to modify the duty to read? I mean, the instruction, I know I paraphrased it, but I'm not sure how a jury would understand what you're getting at there. Isn't essentially what you're saying is there is no duty to read, or the duty to read is somehow modified? Isn't that what the instruction, I guess, could have been, should have been, might have been?
Well, in a perfect world, maybe, Your Honor, but I think that the imputation instruction is sufficient, at least to form a basis for an argument. I was left without an argument backed by law to say, look, if this agent did this of her own accord, as we suggest the phone records show, that's knowledge that's known to Universal, which then it cannot say in good faith it would not have issued. The duty to read instruction was kind of awkward in the circumstances because there was evidence that he didn't read the insurance application. Standing alone in the abstract, failing to read is not an excuse, and certainly the defendant was entitled to some kind of instruction regarding reading. I felt it was a little strong, but had I had a good instruction myself, I think it would have been sufficient to balance it. So,
did you provide the court with the specific instruction that you wanted?
Yes, sir. I read it to him in the record. I read it to the court in the record.
So your argument to us is essentially the duty to read is not absolute.
No, it is not absolute, Your Honor. For example, if the insured didn't read, and I've just pointed out a number of cases in my brief, if the insurance company knows, regardless of what the insured, whether he reads or not, if there's false information and the insurance company either actually or constructively knows it and issues the policy in any event, they're bound.
But those are all cases, as Judge Van Nort was saying, where the agent was told X and he wrote down not X, and therefore the knowledge of X is imputed to the insurance company, rather than the agent never even asked the question, wrote something down.
And that knowledge is also imputed, Your Honor, that the agent did not ask the question.
And if you are correct and that's the law, what's left of the duty to read?
Well, I think, Your Honor, that the duty to read still exists.
But the duty to read, it seems to me, if it has a purpose, the purpose is for the insured to determine whether there's an error in the application and to verify the information that may have been typed in by the agent, which is the common practice. So the question, I would say if you're right and the law is as you say it is, that here the knowledge of that the agent did not ask the question is imputed to the insurance company, wouldn't a typing error by the agent also be imputed to the insurance company? So there would be nothing left of the duty to read except the exception.
Well, I disagree that there would be nothing left of the duty to read, Your Honor. I think that it is when there is conduct, either actual knowledge that the statement is false or knowledge that it may or may not be false when the question is not even asked and the agent inserts her own answer. I think that's a little bit different than a clerical error. And as recently as, I think, 3 or 4 months ago, this court held in Mercury Insurance Company versus Markham in reversing a summary judgment for the insured based on an alleged ambiguity in the application, sent it back for retrial because of the issue of who the agent was acting for. I'll grant you that was positive information, whether a truck had been changed in some way that may have been material. But I suggest to the court this is no less positive when the agent takes it upon herself to complete a question on an application that's ultimately important to her principal and then submits it as though it's the insured's answer. Ultimately, if the insurance carrier is on notice of this, how can it say then in good faith it would not have issued?
But do you have a case where an applicant for insurance signs the application outside the presence of anybody who represents the insurance company, and the application says what this one did about warranting the accuracy of everything and so forth, and the applicant is excused from any inaccuracies that may appear?
Well, signed outside the presence?
I mean, that's the situation here, right? This is not in the agent's office.
It is not.
Or it's not like that case where the agent came and had the person on her sickbed sign. This is outside the site of the insurance company. So as far as they know, he did read it, and where it says everything on here is accurate, he attested to that.
Your Honor, I understand that Universal itself could not have known, but the person it put in place and the relationship between Universal and this agent was such.
Well, she wasn't present when he read or did not read and signed, was she?
No, sir. What she did do was make a telephone call and say, sign this immediately and get it back before 5 o'clock. The evidence shows it got to his office around 4:56.
But that goes back to my question. The instruction I think you really wanted was something that would tell the jury that in evaluating whether he complied with his duty to read, it is, reasonable to evaluate the circumstances that he was placed in at the time. And I'm not sure that's what the law is, but I think I'm kind of reading between the lines, and that's what you're essentially saying. Even if he didn't read it, the reason he didn't read it is because he was, handed to him or faxed to him and told to get back immediately.
Well, as I read, and for example, the John Alden, the warranty, I have a little trouble with that name. We'll call it John Alden case. In that case, I believe Your Honor was referring to the application taken in the home. The agent fills it out and says, hurry up, sign this, I've got another appointment. It's signed, and off he goes, and it has inaccuracies in it. I don't see a great deal of difference between that situation and one where the agent inserts her own answers to questions that were never asked to the insured.
Well, there, the agent saw that she never read the application. So I suggest that is a difference.
Well, and respectfully, Your Honor, in this case, the agent, I'm not even on my second issue, and I'm into my rebuttal. Respectfully, Your Honor, in this case, the agent made the telephone call and said, sign this and get it back by 5 o'clock. By the time the fax came through, this was proven by the phone records, there were less than 4 minutes left between the time he received it and the time that he had to fax it back. This was a situation where he was uninsured. As you may recall from the brief, his insurance had lapsed, and they were trying to get coverage. So it was a situation, and while there may have been a more perfect jury instruction, I never claimed to be the best, I do believe at a very minimum we were entitled to an instruction that explained the legal relationship between the agent and the insurance carrier. Without that, and given the duty to read instruction, there was fundamentally nothing left to try. And regretfully, I'm going to sit down for now and reserve the rest of my time. Thank you.
Good afternoon. Henta Klein here on behalf of the appellee. Preliminarily, I want to emphasize that Mr. Tyler asked for and did receive an instruction that reads, the court hereby instructs you that Ms. Bray was working on behalf of Universal for the purposes of taking this application for insurance. So he did get an instruction that he requested.
But he didn't get the instruction with respect to imputed knowledge, did he?
He did not, because as the judge acknowledged, there were no facts within the agent's knowledge that could be imputed. And what I think the court's questions indicate is that there aren't any questions regarding whether or not there was knowledge on the part of the agent, and the only thing that's being sought to be imputed is the agent's alleged negligence in not asking these questions. And if that's what's sought to be imputed, then that's covered by the instruction that Mr. Tyler did in fact receive. Otherwise, I believe that the court was correct that instructing the jury that facts within the knowledge of an agent can be imputed to the insurance company would be incredibly prejudicial and confusing to the jury because of the fact that there were no such facts.
Except for, as Mr. Tyler argued, the fact that no questions were asked, this specific question was not asked, and the application was filled out in ignorance. That's a fact, he argued. How do you respond to that? But isn't it not a fact?
It's not a fact because the agent disputed that. Well, the agent testified that she did ask those questions.
It's a disputed fact.
It's a disputed fact.
So why isn't that something that should have gone to the jury?
Because that would not have excused the plaintiff's failure to then read the application and check it for its accuracy after he received it.
Well, now,
unless it's a fact similar to the fact in Gaskins, which is an exception to the duty to read.
Except that, as Judge Benton had noted, there aren't really any facts in that case or any other that are similar to this case, where the insured has the application in his possession, has the opportunity to read, and still doesn't read the application. There was no testimony and certainly no evidence, even on Mr. Ferguson's behalf, that he was precluded from reading the application. As a matter of fact, the signature line is on the same page as the 9 questions that he claimed he wasn't asked. And the cover...
Isn't he characterizing the case fairly when he says there's really nothing for the jury to try, that the application says what it says, the applicant attests to its accuracy, therefore, whatever is on the application binds the applicant?
I agree, and that's why we moved for directed verdict on the issue repeatedly. There really wasn't anything in dispute, and as a matter of fact, the facts cover sheet actually instructed Mr. Ferguson to read the application and check its accuracy before signing it back. Now, he claims that 4 minutes was not enough time to read 9 questions on a single sheet of paper, but as was demonstrated by the defense counsel at the trial, it only took less than a minute to actually verbalize those same questions.
And somehow she learned that he had a black Labrador, which is recorded on that same form.
Well, the agent testified that she did, in fact, ask him those questions. The agent disputed Mr. Ferguson's testimony that he was never asked those same questions.
You say you moved for a directed verdict on this point. You also moved and got a directed verdict on the waiver issue.
Yes.
And, of course, they are contending that that was error. What do you say to that?
Well, it clearly was not, because there was absolutely no evidence of Universal's intent to relinquish any right that it had to rescind this policy. Mr. Ferguson only argued in his brief that Mr. Banks, an independent contractor, allegedly authorized repairs on his property, which, of course, Mr. Banks disputed. There was no evidence that Universal held Mr. Banks out as its actual or apparent agent.
Well, is that correct? Because it seems to me the evidence is Mr. Beggs was sent out with forms and documents from the insurance company to meet with the homeowner.
Yes.
Isn't that, in a way, holding him out as an agent for the insurance company?
Well, there was testimony. Mr. Banks himself testified, and I believe Mr. Ferguson agreed, that Mr. Banks advised Mr. Ferguson who the adjuster was on the file. I know her first name was Connie. I don't recall her last name. As a matter of fact...
But only with respect to the issue of whether or not he was going to be paid anything for his living expenses. It wasn't the repair to the home, was it?
Mr. Banks testified that he told Mr. Ferguson that the adjuster was the adjuster for all purposes. Mr. Ferguson disputed that and says he was only told that with respect to the additional living expense. And I believe that there was a letter that Mr. Banks wrote in response to an accusation that Mr. Ferguson made, implying that he was authorized to get a trailer under the additional living expense portion of the policy. Now, the only reason that that letter was limited to the additional living expense portion of the policy was because that was the specific thing that Mr. Ferguson claimed Mr. Banks had told him. But he also testified, Mr. Ferguson, that nobody told him or authorized him to sign a blank proposal for any of the repairs. And there's no question of fact there for that.
He didn't testify that there was a 9-minute conversation during which Mr. Banks told him to sign the contract and put in, as far as the amount, whatever the language to affect the amount of the insurance estimate. He didn't testify to that?
I don't recall that specific testimony, but Your Honor could very well be correct. He, however, also testified that Mr. Banks never told him to sign a blank proposal. And Mr. Banks, of course, disputed all of this and said that he never authorized any such repairs, that he had told them from the inception that only an adjuster could authorize payment of any of the insurance claims. And he received that letter regarding the ALE a full month before any of the repairs began.
Ferguson denies that he was told that, right?
Ferguson admits that he was told about the adjuster, and in fact, he complained that he had called the adjuster on several occasions and didn't receive a return phone call back. So there's no question that he was told who the adjuster was. And presumably, he was told what the adjuster's job was, which was, of course, to adjust his claim.
Did he not deny that Banks told him that he did not have authority to authorize payment of any portion of the claim?
Mr. Ferguson claimed that he believed that Mr. Banks had that authority. I don't recall Mr. Ferguson specifically saying that Mr. Banks told him he had that authority, but that he assumed that he had that authority, because he wasn't specifically told to the contrary.
Wasn't it Banks who said, I have no recollection of the conversation, I cannot really address any of the testimony that Ferguson is giving here?
That's true. He did not have a recollection of that 9-minute phone conversation, but he did say that he never advises insureds that he has authority, that he's only supposed to go out there and gather information, and other than that, he couldn't testify one way or the other as to what he specifically told Mr. Ferguson. He also recalled talking to Mr. Ferguson's contractor, but again, couldn't remember the specifics.
So why is he talking to the contractor?
Well, perhaps the contractor was at the property at the time that he was adjusting the loss. I don't recall the specific facts relative to that conversation.
Are you saying there's no factual disputes surrounding that issue?
Well, there's no factual disputes that would amount to an intentional relinquishment of a known right on the part of Universal, which was the directed verdict.
What if the president of Universal had called and said, go ahead with the repairs, we will pay up to whatever our estimate is? What if that had happened?
That would be an entirely different case, because the president's not an independent contractor.
It would be a hypothetical question, so to help us understand your position. Mm-hmm. In that event, would there not have been something to go to the jury with on the waiver issue?
Absolutely.
Then, are you going to make the next step, Judge Benton?
Please.
Or do you want me to? If that's the case, and there's evidence that of a parent agency, if there's a question of fact about a parent agency, why isn't that enough to then create a question of fact about whether the apparent agent waived the right on behalf of the insurance company?
Because I don't believe that there is a question of fact on the issue of a parent agency. A parent agency requires that the principal, in this case Universal, hold out someone as the agent of the principal. There's no evidence, testimony, or anything else in this record to show such a representation on the part of Universal. The only evidence relied on by opposing counsel is the alleged representations on the part of the alleged apparent agent, which is insufficient to establish an apparent agency binding the principal. And
he calls Universal and says, my house burned down. And according to him, they say, okay, we will send somebody out. And Banks shows up. It doesn't have to be a verbal representation, does it?
No, it does not. Under the case law, obviously, there are those cases where an agent is cloaked with certain authority on behalf of the principal. But there's no evidence in this record that anyone from Universal said that this person is our employee, that this person is there to do anything other than investigate the circumstances of the fire.
In fact, is there any information in the record, or isn't there a dispute in the record, or whether anything was said with respect to Mr. Banks? He just showed up. There was nothing, he didn't bring any document that said he had limited authority. He was just there. So Can't one imply agency from that fact?
That's not the same as a representation on the part of the principal.
Understand it's not the same, but isn't the case law doesn't the case law tell us that you don't need a written or verbal statement as to the authority of the apparent agent?
That's true.
Facts and circumstances.
You absolutely can. And if we were here arguing about a directed verdict on the part of a parent agency, which was an issue never pled or tried in this case, that might be different. But what we're here on is a directed verdict on the issue of waiver. A parent agency was never actually litigated in this case. The only thing litigated was the assumption that Mr. Banks was the actual agent of Universal, and that was clearly and concisely disproven in this case.
But I believe you conceded as a hypothetical matter that if somebody with clear authority, like the president of the insurance company, had done just what the plaintiff testified Banks did, that would have been sufficient to go to the jury on waiver.
Because in that case, there wouldn't be a question as to the authority of that individual. Here we're talking about two different things. We're talking about actual authority, which is how Mr. Ferguson proceeded in this case, and apparent authority, which would apply in the case of Mr. Banks, had that issue been raised and had that issue been litigated. And there was never any kind of instruction requested or given to the jury regarding apparent authority in this case. And no question of fact raised for the jury's consideration.
The whole thing was taken away from the jury.
On the issue of whether or not there was a waiver, not on the issue of a parent agency, only on the issue of whether Universal intentionally relinquished a known right. And on this record, that directed verdict was proper.
Counsel, let me go back to the first issue for a minute. The DUI information. Does the record reflect whether that was an underwriting guideline, official underwriting guideline of the insurance company?
Yes, it does. I believe the executive vice
with the
president.
Department of Insurance and all that stuff?
Yes, it does.
Okay.
If there are no further questions, then I'll rely on my brief. Thank you very much.
Thank you, Ms. Klein.
Your Honor, first I want to address the Labrador. It's undisputed in this record that there was a 10-and-a-half-minute telephone conversation between Mr. Ferguson and the agent, Elizabeth Bray, that occurred about 2:48 p.m., and she filled out then, and it's in evidence, a generic, we call it a generic quote sheet that the agency uses for no particular insurance company. The question about the dog was asked on that generic quote sheet, and the black Labrador appears on that. It was after that generic quote sheet was taken, and that does not have a DUI question on it. After that, when she began looking for companies, she went and did a replacement cost estimate about 3 o'clock, accessed the Alachua County property appraiser's website, and from there developed an estimate, which they later talked about. The black lab came from that conversation. You can see it right on the generic quote sheet. I want you to understand that. There's a suggestion that it takes only a few minutes to read the 9 questions, the background questions.
Let me shift you spent all your initial time on that. We spent a lot of time talking about the last issue with opposing counsel, so I want to make sure you address that concern. I mean, she made a point that the issue of a parent agency was not something tried below and that the case proceeded only on the issue of actual agency. What's your response to all that?
Your Honor, I think that I do believe the parent agency was tried. I would have asked for that jury instruction as well. And I do not have the pleadings in front of me right now, and I don't want to make a misrepresentation to the court. If it was not tried explicitly, it was at least tried by consent. There was certainly evidence elicited regarding Mr. Banks' relationship with the company, the fact that he attended training seminars for them, the fact that they had specific ways they wanted claims adjusted, that he adjusted those claims that way. They exercised control over him in terms of the way he adjusted claims. He reported directly to them, had access to their websites and so forth.
Well, none of that sounds like apparent authority. That sounds like a claim of genuine or real authority? In other words, you're not claiming that the insured knew all of these facts, are you?
No, Your Honor. I believe there was actual agency, and I think the elements of actual agency are acknowledgement by the principal that the agent will act, the agent's acceptance of the undertaking, and control by the principal over the agent's action. So I think that there's actual agency there. But the critical thing I felt to be, the critical issue to be tried was whether in that capacity he had waived the company's defenses while being on full notice of this alleged misrepresentation, because remember, the day after the fire, he took a statement, and Mr. Ferguson admitted he had been arrested for DUI. He was asked those 9 background questions, and he said, yeah, I've been arrested for DUI. At that point, based on the testimony at trial, Universal states that it never issues policies to people who have been arrested for DUI under any circumstances. So at that point, it's gone. By July 20th, the day after the fire, they know they're not paying this claim. It's reported to them. They have the statement transcribed, all done before July 25th and before, and I don't want to say well before, but before the July 30 date when they had the 9-minute conversation. I see that my time is up. I thank you, Your Honor. Does you have a questions?
Go ahead and finish your.
Well, I believe that there was substantial evidence that he was the actual agent of Universal. He was the only person that was ever sent there. There were no limitations on his authority expressed to the insured as based on the testimony of the executive vice president, and that his conduct was the conduct of Universal.
All right.
Thank you.
Thank you.